How's it going, everybody? In this video, I'm giving you some interesting updates on the Young v. Hawaii case that is sitting in the Ninth Circuit and is due for an en banc hearing here on September 24th, 2020. But real quick before we jump into this video, if you think that the only permit you need to carry a firearm is the Constitution and the Second Amendment, go ahead and hit that like button and subscribe. Also want to give a big shout out to one of the main sponsors of the channel, and that is Franklin Armory. Franklin Armory is one of those companies that's really supporting this channel, supporting the Second Amendment causes here in the state of California. They've put out multiple products that we can purchase here in the state of California, as well as they put other products out on the market that people in free states can benefit from. So Franklin Armory is just an amazing company. They've shown us a lot of support here on the channel, and they support what we're doing here. So go over to their website, go over to their social media accounts, and go show them support. Now, I'm not going to talk comprehensively about what Young v. Hawaii is about. I have another video, you can click that right there, and it's like an 18-minute video where we dive deep into all the complexities of what exactly this case deals with. But in short, what it is the challenge to Hawaii's various statutes and laws which restrict an individual's ability to carry not only a firearm concealed, but also open. And Mr. Young challenged that law when the district court, he was denied in the district court, went up to the three-judge panel level in the Ninth Circuit, and the Ninth Circuit found that Hawaii's laws restricting an individual's ability to carry a firearm openly violated the Second Amendment, and they used a lot of historical context to come to that decision. That decision by the three-judge panel was then sought for a rehearing en banc, and this was like back in 2019, and it was essentially shelved because the Supreme Court was supposed to hear the New York Rifle and Pistol Association case, which was eventually found moot. And so now it's back in the Ninth Circuit, and the en banc panel is actually going to be hearing this case. And like I mentioned, they are hearing this case September 24, 2020, but we got an update as far as what the makeup of the 11-judge panel is going to be for the en banc hearing. And it's actually very interesting. What it's going to look like is 6 Republicans and 5 Democrats. So I'll go ahead and list what these judges are, who these judges are, and I'll put a link down in the details as well to the calendar so you can look for yourself what the judges are. And it's going to be the Chief Judge Thomas, which the Chief Judge is always sitting on en banc panel hearings, so that was a given that the Chief Judge Thomas was going to be on there. And then it's going to be O'Scallion, McCowan, Wardlaw, Fletcher, Clifton, Bybee, Callahan, Ikuda, Friedland, and then R. Nelson. What's also interesting about the makeup of these 11 judges is that all 3 judges, which were on the 3-judge panel on this specific case, are also sitting on the en banc panel. And so that is O'Scallion, Clifton, and Ikuda. So it's actually interesting that the 3 judges who actually ruled down below are also going to be sitting on this en banc court as well. Now, as far as the 6-5 makeup, that is primarily because recently Donald Trump has appointed a lot of Republican judges in the Ninth Circuit, and it's pretty much completely changed the makeup of the Ninth Circuit, and that's why I think we're getting a lot of these favorable Second Amendment cases, which we weren't getting previously. I mean, the Ninth Circuit is being known for being very liberal, and they actually are not Second Amendment friendly at all, but we've been getting a lot of interesting decisions lately, and that's because the Ninth Circuit has been packed with a lot of conservative judges recently. So although the makeup might be 6-5 in favor of Republicans, one of the issues is that Clifton, who was also one of those individuals that sat below on the 3-judge panel ruling, he actually, although was appointed by Bush, actually wrote the dissent. So down below, it was a 2-1 in favor of finding that Hawaii's law was unconstitutional, but Clifton was one of the individuals who dissented. And so it's not going to be very clear cut that everybody's going to be along party lines, because we've already seen Clifton down below in his 3-judge panel ruling finding that he did not agree, and in his dissent he said that pretty much Hawaii's statute did not violate the Second Amendment. And so another interesting thing with this case has to do with, although this is a challenge specifically to Hawaii's statute on open carry, if the panel here upholds the 3-judge panel's ruling and finds that Hawaii's statute is indeed unconstitutional and violates the Second Amendment, this might have greater impact for the state of California and might have greater impact sooner rather than later here in the state of California, because we already have a case that is being teed up in regards to open carry in the state of California in the Eastern District section. So we already have a case that's teed up, and that is the Baird v. Becerra case. Now, I'm not going to talk comprehensively about what Baird v. Becerra is about, and if you guys would be interested in that video, I can definitely make a video about that. But essentially, it's a federal district court case where the plaintiff is actually challenging California's structure around its open carry laws and its concealed carry laws. And specifically, we actually had some interesting language here in this case when the judge issued their recent order, because the plaintiffs here were seeking a preliminary injunction on California's language on open carry. And in light of the Young v. Hawaii case and the en banc panel's potential rehearing, and also the three-judge panel's ruling that Hawaii's law was unconstitutional and it violated the Second Amendment, and that these open carry structures are potentially violating the Second Amendment, the court here actually said that they were leaving the door open. So if the en banc panel actually rules in our favor and finds that Hawaii's statute is indeed unconstitutional, violates the Second Amendment, upholds the three-judge panel's ruling down below, the plaintiff here in Baird v. Becerra can then go and say, look, the three-judge panel found that Hawaii's law was unconstitutional, as well as the en banc panel found that Hawaii's law is unconstitutional. We would like to apply that same logic to the California's language, and then they can seek another preliminary injunction based on that. So the process is already going on here in the state of California. Here in the state of California, we already have a case kind of teed up, waiting for a determination by the en banc panel in Young v. Hawaii. So this is actually kind of interesting to me, and it could have major implications for the state of California sooner rather than later. So we're definitely going to be keeping an eye on this. But this is interesting because we got the makeup of the 11-judge panel. We know it's 6-5, but we know Clifton, who is allegedly a conservative Republican, dissented down below. So we know that he's going to find that the Hawaii statute does not violate the Second Amendment. But those other two judges as well, who are on the 3-judge panel, will be sitting on the 11-judge en banc panel. So we know that just right off the bat, we got 2 that find that Hawaii's statute is unconstitutional, and we have 1 who thinks that is not unconstitutional. So we already know we have a 2-1. How the other judges are going to fall in place, we don't know. Another interesting thing is that Callahan is also sitting on this 11-judge panel. And you guys might remember Callahan from the Duncan v. Becerra case, where she sat on the 3-judge panel in Duncan v. Becerra and found that California's magazine restriction law was unconstitutional, violated the Second Amendment. So I think we can really guess where Callahan's going to lead. So we know it's a 3-1. But again, we have a lot of other liberal judges that are sitting on this en banc panel. So we don't know fully where everybody's going to lie, but we can guess where some of them are going to rule, how they're going to rule. And we'll get definitely a good impression by the live oral arguments about how everybody is going to rule, because a lot of these judges tip their hands when they are at the oral arguments, and you can really guess how they're going to lean in their decision. And like I mentioned, if you guys be interested in a live stream and where you can kind of get my interaction with what's going on in the Young v. Hawaii case, we can definitely do that, and go ahead and comment down below if you'd be interested in that video. But so that's just a quick update on Young v. Hawaii. I'm definitely excited about this. Like I mentioned, September 24th, it's coming sooner rather than later. And if you'd be interested in that live stream, we can definitely do that. If you like this video and you'd like to support the channel, one of the best ways to do that is join the Patreon page, and I'll go ahead and put a link down below to the Patreon page. Also, just like, commenting, and subscribing, and make sure you hit that notification bell, because that helps the channel analytics, helps us spread the word about the Second Amendment and what we have to deal with here in the state of California in regards to the state of California infringing on our Second Amendment rights. So as always, thanks you guys for watching. Don't forget to like, subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.